Case 13. Abdullah versus American Airlines. We find ourselves in the U.S. Court of Appeals for the Third Circuit. Facts. Plaintiffs Khaled Abdullah, Audrey James, Eardley James, and Velma George were passengers on American Airlines Flight 1473 from New York to San Juan, Puerto Rico, on August 28, 1991. En route, the aircraft encountered severe turbulence, which caused serious injuries to several passengers, including the plaintiffs. The first officer had noticed a weather system developing in the flight path and had illuminated the seatbelt sign. He had also gone to the back of the aircraft to warn the flight attendants that the ride could get choppy in 10 minutes. None of the crew, however, alerted the passengers of the expected turbulence, nor did the pilot change course in order to avoid the storm. Some of the injured passengers were wearing their seatbelts. Some were not. Plaintiffs filed 2 separate lawsuits against American, alleging negligence on the part of the pilot and flight crew in failing to take reasonable precautions to avoid the turbulent conditions known to them, and in failing to give warnings reasonably calculated to permit plaintiffs to take steps to protect themselves. A jury trial commenced on August 7, 1995 in the District Court of the Virgin Islands, Division of San Juan. The plaintiffs' cases were consolidated for trial. On August 25, 1995, the jury found American liable, found plaintiffs to be without any contributory fault, and awarded monetary damages aggregating more than $2 million. American filed a post-trial motion which requested dismissal and/or a new trial plus attorneys' fees and costs. Among the grounds asserted was that the district court had improperly used territorial common law to establish the standards of care for the pilots, flight attendants, and passengers. American argued that the FAA implicitly preempts the standards for airline safety. The district court issued an opinion on June 5, 1997, holding that the FAA impliedly preempts state and territorial regulation of aviation safety and standards of care for pilots, flight attendants, and passengers, but that plaintiffs may recover under state and territorial law for violation of federal standards. The district court held that its error of law regarding preemption, which resulted in admission of evidence regarding standards other than federal standards, warranted a new trial. So here we are, the issue. Does federal law preempt the standards for air safety, but preserve state and territorial damage remedies? Here's the holding. The court answered both parts of this certified question with a yes. As to the first part of the question, contrary to courts that have found that federal law does not preempt state and territorial air safety standards, or that federal law only preempts discrete aspects thereof, we find implied federal preemption of the entire field of aviation safety. As to the second part, we conclude that despite federal preemption of the standards of care, state and territorial damage remedies still exist for violation of those standards. Let's discuss now the reasoning behind this holding. The court's finding on preemption is based on the determination that the FAA and relative federal regulations establish complete and thorough safety standards for interstate and international air transportation, and that these standards are not subject to supplementation by or variation among jurisdictions. Thus, the court agrees with the district court that it was error to rely upon territorial safety standards in determining Americans' liability in this case. In coming to their conclusion on preemption, the court did not, however, agree with the narrow nature of the federal standards set out by the district court. They concluded instead that there is an overarching general standard of care under the FAA and its regulations. This standard arises in particular from 14 CFR 9113. No person may operate an aircraft in a careless or reckless manner so as to endanger the life or property of another. Thus, the court did not agree with the district court's determination that evidence on reasonable standard of care should necessarily have been excluded, as long as a reasonable standard of care is compatible with an avoidance of recklessness or carelessness in the operation of the aircraft. The court remanded this case to the district court to review both the testimony and the jury instructions on standards of care in order to determine if they are consistent with the standards they set out here. If they are, the jury verdict should be reinstated. If they are not, the district court should proceed with a new trial, and in that trial, the court should follow the federal standards as they established them here. Let's talk about the Federal Aviation Act of 1958 for a moment. The legislative history of the Federal Aviation Act reflects that Congress intended the administrator, on behalf of the FAA, to exercise sole discretion in regulating air safety. In fact, Congress accomplished this in the FAA when it enacted Chapter 447, Safety Regulation, and directed the administrator to, in quote, carry out this chapter in a way that best tends to reduce or eliminate the possibility or recurrence of accidents in air transportation. The court determined that state and territorial standards of care relating to safety are federally preempted. Here are some examples the court provided as evidence that Congress intended the FAA to exercise sole discretion in regulating air safety. To effectuate broad authority to regulate air safety, the administrator of the FAA implemented a comprehensive system of rules and regulations, which promotes flight safety by regulating pilot certification, pilot pre-flight duties, pilot flight responsibilities, and flight rules. 14 CFR 61.3. No person may act as pilot in command or in any other capacity as a required flight crew member unless he has in his personal possession a current pilot certificate. Before flight, the pilot must review available information concerning the flight, verify the aircraft's airworthiness, ensure that passengers are briefed on the use of their seatbelts. No person may operate an aircraft in a careless or reckless manner so as to endanger the life or property of another. Furthermore, 91.7 mandates that the pilot in command shall discontinue the flight when unairworthy mechanical, electrical, or structural conditions occur. And lastly, 14 CFR 91.101 states, this subpart prescribes flight rules governing the operation of aircraft within the U.S. and within 12 nautical miles from the coast of the U.S. Given these rules and the legislative history of the FAA, and its judicial interpretation indicating that Congress's intent was to federally regulate aviation safety, the court found that any state or territorial standards of care relating to aviation safety are federally preempted. Its analysis was sustained by reference to the broad scope of the FAA. It also was supported by decisions in which courts found federal preemption of discrete safety-related matters such as airspace management, flight operations, and aviation noise, because of the promulgation of specific federal regulations over those aspects of air safety. According to the court, it followed from the evident intent of Congress that there be federal supervision of air safety, and from the decisions in which courts have found federal preemption of discrete safety-related matters, that federal law preempts the general field of aviation safety. Indeed, the court concluded, it would be illogical to conclude that while federal law preempts state and territorial regulation of matters, such as pilot licenses, it does not preempt regulations relating to the exercise of the specific skill for which licensing is necessary for pilots' operation of aircraft. All of this exemplifies the field preemption prong of implied preemption. The court noted that other courts had reasoned that federal law does not preempt state and territorial safety standards because Congress directed the administrator to prescribe minimum standards to promote safety. Because the federal standards are minimum, some courts have determined that a common law duty of safety may be owed beyond the FAA regulations. The court had a problem with applying the type of analysis to determine there is no federal preemption of aviation safety. First, there is no gap in the federal standards to fill with a state common law standard. 9113 prohibition of careless or reckless operation of an aircraft occupies the apparent void beyond the satisfied minimum standards. Therefore, because the administrator has provided both general and specific standards, there is no need to look to state or territorial law to provide standards beyond those established by the administrator. And second, in a federally preempted area, the question whether state or territorial law conflicts with federal law is a pointless inquiry. If Congress has preempted a field, whether it can be expressly or by implication, state laws attempting to regulate within that field will be invalidated, no matter how well they comport with substantive federal policies. The FAA Savings Clause provides that a remedy under this part is in addition to any other remedies provided by law. The Insurance Clause requires that airline maintain liability insurance for bodily injury to or death of an individual, resulting from the operation or maintenance of the aircraft. These two sections have been interpreted to mean that state safety standards are not preempted because Congress provided for compensation of injured persons. Moreover, these two sections demonstrate that Congress intended to allow for compensation of persons who were injured in aviation mishaps. The court did not find that state and territorial law remedies are preempted, only the standards of care for the safe operation of aircraft. For that reason, the inclusion of the savings and insurance clauses in the FAA was not inconsistent with the court's decision. The district court pointed out that some courts have found that federal law does not preempt state law in the field of aviation safety because they believe that states may regulate aviation safety under their traditional police powers. However, whether the states could invoke their police powers depended on whether the field was federally preempted, according to the court. As a result, because the court found that the entire field of aviation safety was federally preempted, it did not consider whether the regulation of aviation safety fell within the traditional police powers of the states and territories. Also, because the court found Congress's intent to regulate interstate and international air safety to be unambiguous, it held that state and territorial standards of care in aviation safety are federally preempted. Moreover, the court found that state and territorial tort remedies can coexist with federal standards of care for air safety. Thus, plaintiffs who are injured during a flight as a result of the violation of federal air safety standards may have a remedy in state or territorial law, according to the court. And in fact, the case was remanded to the district court to evaluate whether the evidence on standards of care and the instructions given to the jury conformed to federal aviation standards.